Another interesting case that has been in the news lately, issues of protection, allowing people to investigate terroristic activities. There was a humanitarian group that I'm sure you read about, who wanted to explore and give some advice to a group as to peaceful means of resolving disputes, right, because they were dealing with the terrorists. They were the ruling came down on the side that they were actually kind of aiding and abetting. Yeah. What do you feel about that?
Yeah, I mean, again, the Supreme Court case on this is very recent, highly controversial. I think it's important to understand, broadly speaking, two sides of the issue. One, it is in the United States, even if not in virtually every other country in the world, legal to advocate illegal action. It is okay to advocate illegal action. It is okay to advocate overthrow of the government. It is okay to advocate terrorism. The U.S. is stronger by far than any other country in the world on the protection of people who would advocate violent overthrow of the government, subject to the exception of if you're standing in front of an angry mob and say, go get them right now, that can be restricted. But short of that, advocacy of violence, advocacy of illegal action, advocacy of murder, advocacy of overthrow of the government, all of that is protected. On the other side of that, outside of, broadly speaking, the public political arena, there's a whole realm of speech that relates to criminal conspiracies, speech that relates to aiding and abetting a crime. Doesn't come anywhere near the First Amendment. If I work for a bank and I say to you, maybe this is a dated example, I don't think banks have safes anymore, but if I work for a bank and I say to you, you might be interested in knowing that this is the combination to the bank safe and these are the hours when the guards are off duty. If you rob the bank, I can be prosecuted as an accomplice or aider and abetter or co-conspirator, and my free speech objection isn't going to get me anywhere. So when we're outside of the public political arena, person-to-person speech that's part of a criminal conspiracy or part of a criminal act has nothing to do, virtually nothing to do with the First Amendment. Indeed, the conspirators of the first World Trade Center bombing, going back, 15 years ago, maybe even more, 15, a little bit more years ago. Some of the people prosecuted for conspiracy for the first World Trade Center bombing were basically prosecuted for organizing the conspiracy. Nobody even took seriously a First Amendment objection, even though what the conspirators had done was encourage certain violent acts, but they'd encouraged it in private settings. They'd provided assistance in private settings. All of that is to say that on the issue that the Supreme Court just decided, on the one side, we have the very strong tradition of protecting advocacy of virtually everything, no matter how violent, no matter how encouraging of terrorism or illegal action it may be. And on the other side, we have an equally long tradition that not every use of words comes close to the First Amendment, and a whole range of non-public criminal conspiratorial activities have never been thought to raise First Amendment questions at all.
From a legal point of view, does one of the reasons what you've just said obtain because if you incite someone, it presumes an action? I mean, is there some connection there legally?
Technically, incitement does not require an action. It presumes that you want an action to occur. But if I stand, take a local example. Suppose that at 10 minutes to 5 this past Thursday, I am standing in front of a government office, in front of a very angry mob, and I say to these people, we have had enough of government. Let's go break into the building and burn all of the records right now. Let's go. And at the moment I say let's go, the 10-minute thunderstorm that wiped out all of these trees happens, so that there's no actual act. I can still be prosecuted for that act of inciting, even though there was no subsequent act. So under current law, incitement to illegal action or incitement to violence can be prosecuted if and only if there are explicit words of incitement, only if the incitement is to an act that is to occur immediately, imminently is the term of art, and only if it is likely to happen. That's a very stringent standard, which is why almost nobody these days is prosecuted for this, but the act doesn't have to actually occur.
Okay. Does the Constitution specifically mention the right to privacy, or is it implied in the Bill of Rights by the 3rd, 4th, or 5th Amendments?
It does not specifically mention it at all. Whether there is one has been controversial, and if there is one, where it comes from has been controversial. When the Supreme Court in 1965 first said there was a right to privacy in the context of a right to purchase contraceptives, Justice Douglas found it in some amorphous combination of the First, Third, Fourth, Fifth, and Ninth Amendments, when in 1973 the Supreme Court decided Roe versus Wade. It found it in the Due Process Clause. It's not explicitly
I want to
mentioned.
come back to this. We have to take a break.
Sure.
We're talking with Professor Schauer, and we will be back to you. This is Politics Matters. We will be back to you in a moment.
What if your brother
or your husband?
What if your son came back from the service with a spinal cord injury?
In a wheelchair?
When they volunteer to serve, we expect our country to be there for them if they are injured.
For more than 60 years, Paralyzed Veterans of America has been fighting to ensure that we receive all of the benefits that we've earned.
Thank you, Paralyzed Veterans, for helping my husband.
My son.
for helping my brother.
You too can help. Visit pva.org.
Hey, what can I get you?
Do you have a chai tea?
We just have black coffee in a medium cup.
You just have black coffee?
No teas, no lattes, no espressos.
Really?
Just black coffee in a medium cup.
Well, good luck.
For thousands of Virginians with disabilities, daily life is much the same way because they have no choice in where they live or the services they receive. Tell Virginia the time for choices is now. Register your support at abletochoose.org.
Welcome back to Politics Matters. I'm Jan Painter. We're talking today with Professor Frederick Schauer about amendment issues, and before the break we were discussing the issue of right to privacy. Professor, what is the current state of legal debate in this age of emails, internet chat rooms, Facebook, and Twitter concerning the right of people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure, and as cited in the Fourth Amendment?
Okay, I think there are two very different issues here. A lot of times when people worry about privacy, they worry about it in the context of knowledge of or publication of information about them by, broadly speaking, non-governmental entities, whether it be credit bureaus or banks or newspapers or whatever. The privacy that is now understood to be part of the Constitution is a protection against the government and only against the government. Protection of my privacy against a bank, against any other private institution is a matter of statute. It may be a matter of common law. It's not a matter of constitutional law. Doesn't mean it's not important. It doesn't mean there are not important debates. And there are very extensive statutory, state and federal protections of privacy. But the Constitution only protects us against government and not against non-governmental entities. In terms of privacy, most of the Supreme Court decisions about privacy have dealt with abortion, contraception, and the like on the one hand, or the protection of criminal defendants through the Fourth Amendment that you quoted against unreasonable searches and seizures and the like. Most of the forms of privacy that people worry about do not involve either of those. And whether the Constitution protects against, for example, government databases is something that the Supreme Court has never touched. It hinted that there might be some protection. The hint was 20 years ago, but direct Supreme Court decisions about government databases and all of this that lots of people are worried about, again, it's pretty much a blank slate.
This is speculation, I realize, for you, but I wanted to probe a little bit more. Why do you think the Supreme Court is so reluctant to wade in?
That's a big question, but one, let me make your bigger question even bigger. It is a mistake to think that the Supreme Court deals with the most important issues of our times.
Interesting.
Most of what the Supreme Court does is important. Most of what is important is not done by the Supreme Court. If we look over the issues that are most important over, let's say, the last 2 or 3 years, it seems to me that the four most obvious are the wars in Iraq and Afghanistan, healthcare reform, financial reform, including bank bailouts and maybe even automobile company bailouts, and most recently, the massive oil spill in the Gulf. The Supreme Court has had virtually nothing to say about any of those and will not.
Thank you again very much, Professor Schauer, for being with us today. Thank you for listening to our conversation. We would like to hear from you with all questions and concerns. You can email us at info@politicsmatters.org. Thank you again. I'm Jan Painter, and this is Politics Matters.